Welcome all to the third annual Justice Week Intervarsity debate, which the Bar of Ireland is delighted to be hosting this year in person, and no less. My name is Ali Ziad. I am a practicing barrister here in Dublin, a member of the Young Bar Committee, and I will be chairing this evening's debate. Justice Week is an annual campaign of the legal professions across the 4 jurisdictions, namely Ireland, Northern Ireland, Scotland, England, and Wales. And its purpose is to increase support, understanding, and awareness of the rule of law and justice among young people. Now, there is always the risk when giving a barrister access to a podium that they will turn it into a soapbox. And in that regard, I would just like to very briefly condemn the flagrant breaches of international law that are currently taking place in Ukraine. I have read reports of the invasion being described as surprising in the 21st century. And in the context of tonight's debate, I see it as important to note that the invasion of Ukraine is unfortunately not surprising. The 21st century has seen and continues to see far too many breaches of international law. And as citizens of a neutral country such as Ireland, we are in the unique position to be able to condemn all such breaches equally and in the strongest possible terms. Now, there's just some housekeeping matters that I would like to note at this stage. We are inviting all in attendance to wear face covering if they so please. And of course, participants can feel free to wear a mask or otherwise, particularly when they are speaking. Now, the bathrooms are located just outside the door on your right-hand side. And I just would like to note that the participants in Team A, which is for the proposition, are Spillane, Mohammed Awan, Hira Khan, Melissa Ferris. And for Team B, for the opposition, we have Adam Connolly, Emer Nolan, Emma and Katherine Ahern. We also have a very prestigious panel of judges with us tonight. Firstly, we have Dr. Tom Clonan, who's a graduate of Trinity College. He is a university in the Technological University in Dublin. He's also a journalist, being the Irish Times security analyst from 2001 to 2016, and security analyst and columnist with the journal.ie. Mark de Blackham, senior counsel, was called to the bar in 1977 and to the inner bar in 1999. Anyone doing the maths will know that that's a very impressive 23 years as a senior counsel. And Mark is also the author of one of the foremost texts on judicial review in Ireland. And I can positively assert that his book has been a guiding light to me in the past. Maura McNally, senior counsel, is the current chair of the Bar Council and was named Irish Woman Lawyer of the Year in 2020. Maura is a graduate of what is now NUI Galway and the King's Inns, and was called to the bar in 1992 and the inner bar in 2017. Maura has also recently been appointed chair of the first governing body of the New Atlantic Technological University, which will open its doors in April of this year. Finally, and certainly not least, Miss Justice Nuala Butler is currently a judge of the High Court. Judge Butler is a graduate of University College Dublin and the King's Inns, and was called to the bar in 1986 and the inner bar in 2003. She was a member of the Employment Appeals Tribunal from 1989 to 1992, chaired the Mining Board from 1999 to 2002, and chaired the Incorporated Council of Law Reporting for Ireland from 2016 to 2019. I would like to welcome our judges and thank them for their time in judging in tonight's debate. Now, without further ado, the motion for this evening's debate is as follows. This House believes that international human rights law and international humanitarian law provide adequate protections in respect of the use of autonomous weapons and systems in warfare. And I will now pass you over to the debate itself. Thank you.
Ladies and gentlemen, following the tragic aftermath of World War I and World War II, it was a universal hope that we had learned from the tragedies and that the idea of another world war was something in our past that would never be forgotten and also never be repeated. However, in the past few weeks, we have never felt closer to history. The motion brought before the House today captures that in its entirety. And while the developments of technology in warfare will result in unprecedented tactics, the result of war remains the same now as it did 100 years ago: mass destruction. In order to define this motion, I am going to clearly set out, first of all, what is autonomous warfare, or AI, the meaning of adequate protection, and the function of international law and humanitarian law. AI in warfare refers to automated systems which have the ability to carry out targeted lethal force without the need for human intervention. In terms of defining adequate protection, it is important to recognize that we are not referring to full protection or a magic solution to fair warfare. One could even question as to whether the term fair warfare is an anomaly. The reality for both sides of this House is that there are flaws in ensuring protection with regard to cyber warfare. However, this side of the debate argues that the failings are not failings of the law, but a fault in another mechanism that influences warfare. Adequacy in this debate is not a question of perfection, but a question of whether the purpose is being fulfilled. Therefore, the protection offered from the law is adequate as defined in this debate. Lastly, the definition of the function of international law and humanitarian law. International law has its base in its peacekeeping capacity, while humanitarian law serves the purpose of limiting the effect of armed conflict. The important thing to recognise here is that with both international law and humanitarian law, neither can or even seek to bind or control the actions of a state. The purpose of these laws are not to end all wars, because unfortunately that is an unachievable aim. Their purpose is to ensure that the impact of a war is minimised as much as reasonably possible. My argument in this debate has 2 points. First, that the assertion that changes in international law and humanitarian law will result in an increased overall protection in modern warfare is ignorant of the complexity of war. Second is that any argument that the law as it is outdated is a weak one. The law is not outdated in terms of modern warfare and technology and can be applied to such. On to my first point, if violent leaders would do so much as to follow the letter of the law, then that tells them strictly what they can and cannot do in warfare, then we wouldn't have any problem. The ordinary person can recognise this as being unrealistic. Changing international and humanitarian law to place obligations on leaders with regards to how they carry out warfare will simply not be adhered to. Therefore, international law and humanitarian law must focus on those being impacted, the citizens. The aim of the law is to protect them as much as is possible and to minimise the harm that they may incur. So far as the functions and capacity of international and humanitarian law goes, they are providing adequate protection.
One question. Go first. Would you argue that allowing an automated weapon that cannot distinguish a civilian from a combatant is adequate protection?
But the thing is, that is really outside the realms of international or humanitarian law, because the advancements in technology, as with any other war, are going to come as they come. So the most that we can do is protect the citizens as much as possible. You aren't going to stop the way that a country decides to fight its war. Thank you for your point, though. And the argument that international humanitarian law could serve to stop an insane dictator, frankly, does not belong in this debate. This is a problem that requires a different approach, which is not the focus of today. On to my next point, to assert that the law as it currently stands is too old to deal with modern technology has no place. The nature of law is to be broad and flexible so that it can be applied and incrementally developed to novel cases and situations. In World War II, jet aircrafts were used in combat for the first time. Granted, we have progressed light years in technology overall since the 1940s. However, the principle here is that they were facing a new technology in warfare like we are today. Since World War II, international and humanitarian law have developed significantly because of its impact. Therefore, it is equipped to deal with the developments of technology in warfare. So it's totally an inaccurate representation of how the law operates to assert that the time it was written merely leads to it being outdated. That is untrue, The law is broad and adaptable and is therefore capable of offering adequate protection as it stands. My teammates will further demonstrate that while there are issues with the protections, these do not stem from failings in the law. Anne will outline what the legal measures in place are and will show you that they are serving their purpose. Mohammed will show you that to achieve protection with regards a full protection, that lies with alternative solutions. Hira, as our final speaker, will take the arguments of myself, Anne, and Mohammed, and as a whole show you that international law and humanitarian law do provide adequate protection. Overall, to assert that international law and humanitarian law are failing because they cannot save each individual or end the catastrophic impacts of war is not only an unfair assertion, but is a totally unrealistic ideology. Warfare has caused devastation along every era of technology. So to contend that the law is the reason that modern warfare has the potential to cause mass destruction is utopian, is unfortunately far more complex than this. Never prouder to propose.
There are currently no regulations surrounding the use of autonomous weapons and systems of warfare. Think about that for a moment. There are no specific regulations for the use of autonomous weapons and systems in warfare. Adjudicators, members of the opposition, ladies and gentlemen, a computer cannot be allowed to be the sole decision maker in determining who gets killed, what villages are targeted, what is deemed a weapon, and what is not. My name is Katherine Ahern, and I am opening the submissions on behalf of my team for the opposition. The motion before us today is that international human rights law and international humanitarian law provide adequate protections in respect of the use of autonomous weapons and systems. The question I ask of you today is how can international human rights law and international humanitarian law even be considered as providing adequate protections if the very thing they are meant to be providing protections against aren't even mentioned? Furthermore, we currently do not even have so much as an internationally agreed upon definition of autonomous weapon systems. We do recognise that it is an undisputed fact on the international stage that any autonomous weapon system must be capable of being used and are used in accordance with international law. However, we will be making the argument that autonomous weapons and systems are not capable of adhering to either international human rights law or international humanitarian law. For the purpose of this debate, we, the opposition, are using the International Committee of the Red Cross's definition of autonomous weapons, which is any weapon system with autonomy in its critical function. That is a weapon system that can select and attack targets without human intervention. It is important to make the note at this juncture that we are not proposing an outright ban on autonomous weapons and systems, but rather are looking for them to be heavily and specifically regulated. Johan Lewis wrote in the Yale Law Review Journal back in 2015 that this argument begins from the premise that the best approach to autonomous weapons is the one most likely to reduce human suffering. My colleagues on the proposition team are trying to make the point that international law as it currently stands is sufficient to protect the public from autonomous weapons. Well, allow me to ask another question of you. If international law is sufficient, then why is there absolutely nothing stopping or regulating Vladimir Putin right now from deploying thousands of autonomous weapons onto the innocent people of Ukraine? I have mentioned previously that autonomous weapons and systems are incapable of adhering to international law. I would like to address this in a little more detail. The complete lack of regulation surrounding autonomous weapons not only leaves us with a serious legal issue, but also a moral one. Pentagon defense expert and former US Army Ranger Paul Scar explores this legal and moral issue in his book, Army of None. Scar recalls a time when his unit was on a scouting mission in Afghanistan, when their presence was discovered by the Taliban. The Taliban sent out a 6-year-old girl who unconvincingly pretended to be herding her goats while really reporting on the location of the soldiers. Now, the laws of war do not set out an age for combatants. This 6-year-old girl, under the laws of war, was acting as a Taliban combatant and was engaging in military operations near US soldiers. Those very laws of war would see it legal to shoot her. Scar goes on to make the point that, of course, the soldiers would never dream of harming a child, but an autonomous weapon would programmed to follow the rules of war wouldn't even consider details like that. A 6-year-old child would be seen as an insignificant detail. Another story I would like to recall for you is that of Hugh Thompson. Mr. Thompson was a US helicopter pilot during the Vietnam War. One day, he came across fellow American soldiers who were killing innocent Vietnamese civilians. Mr. Thompson landed his helicopter between the US troops and the villagers and made the order to his men to shoot their fellow Americans if they attacked the civilians. This is an order that wasn't taken lightly and many might say was wrong. But when asked why, Mr. Thompson said it was because of the way he was raised and the values he was taught. Making such an order weighed heavily on him, but it was the right thing to do in this situation to protect the lives of innocents. The point I'm trying to make is that sometimes soldiers are faced with impossible decisions, but where a soldier would have a moral compass, an autonomous weapon would not. Autonomous weapons are unequipped and unable to make such moral considerations. This concludes the arguments that I will be presenting before you today. My team will continue with our next speaker giving you an overview of previous failures of human rights law and why it still fails to satisfy here. Our third speaker will discuss the principles of distinction and proportionality. And our fourth speaker will talk about how the unregulated use of autonomous weapons and systems breaches an individual's human rights. Thank you.
We know that since World War II, there has been increased automation of weapons. We know that there is currently a power race, that China, has pledged to invest 150 billion in the next years to ensure the world's leading innovation center for atomic weapons. We know that we are currently in a state of great urgency and exigency, as specified the Ukraine situation, against a president who's been quoted to saying that whoever becomes the leader in this sphere will become the sphere of artificial intelligence, will become the ruler of the world. So what we do not know and what we must discuss today is whether or not the protections provided by international human rights and international humanitarian law provides adequate protection in regards to the use of autonomous weapons and systems in warfare. Ladies and gentlemen, my name is Spillane and I am the second speaker for the proposition in this debate. My colleague, Ms. Melissa Ferris, has already set out and defined so that we now understand what exactly autonomous weapon systems are. So what we must now do is dissect this motion further. It is to question two outstanding things. What protections are currently in place, so what we have, and why are these protections adequate? As I will demonstrate to you, the answers to both of these questions bear the inevitable conclusion that the current protection mechanisms provided by international regimes are in fact adequate. So my first point is what we currently have. As my friends in the opposition have repeatedly made the submission that there is no current international regime around the protection of autonomous weapons and systems. However, I would like to submit that this is in fact a misimpression of the law. That blends greater weight and urgency to the call for some new law or some, preemptive ban to address the current situation. This is not the case, however. Autonomous weapon systems of any kind, indeed, all weapons are subject to LOAC, the International Law of Armed Conflict. The body of international law, also known as international humanitarian law, regulating the conduct of warfare. So a requirement under the LOAC is that states conduct legal reviews of weapons to determine if they are lawful weapons based on certain long-standing baseline requirements. Additionally, all the law of targeting and other fundamental rules of LOAC, including any form of automated weapons or any form of weapon. Why does this matter? Well, this matters because despite the attention garnered by both the NGO campaign, such as killer robots, and demands for a new protocol or law, as my friends in the opposition would have you to believe, there is already an adequate legal process for the legal review of weapons. Under LOAC, atomic weapon systems are regulated by a well-established bodies of law that applies broadly, including to any new weapons that are invented. Indeed, there are very few types of weapons, such as chemical weapons, that are governed by their own special set of international treaty rules. That sort of specialized regulation is the exception, not the norm. So the question that fronts us next is, do atomic weapon systems, do they meet the requirements of an LOAC? Losing Humanity organization established by the International Rights Group of Human Rights Watch asserts flatly that atomic weapons now or in the future, and no matter how advanced artificial intelligence might one day be, will not be able to comply with the requirements of LOAC of distinction, proportionality and precaution.
POI, what would you say to the point that the LOAC, when referring to autonomous weapons, has to have a human being behind every autonomous weapon making that final decision?
So thank you so much for your question. And that is in fact an excellent question. However, the point that I would like, and the proposition would like to make today, is that every autonomous weapon has in fact an element of human conduct. So for example, as many in applying the rules of LOAC to autonomous weapon systems, it is essential to understand that before an autonomous weapon system is used in a military operation, human commanders and operators employing it generally will continue to be expected to exercise caution and judgment about such things as the likely presence of civilians and the possibility that they may be inadvertently injured or killed, as well as many other factors. So ultimately, although a weapon may be autonomous, and much of the requisite legal analysis would still be conducted by human decision makers. So to conclude, my argument today is that there is in fact regulation governing autonomous weapon systems, and why this is so good is because it broadly applies to an area that is constantly evolving, that demands we garner a law that allows for the evolving nature of technology of autonomous weapon systems. Thank you very much.
Ladies and gentlemen, this debate has more relevance today than could ever have been anticipated when this motion was set. Just last week, this has moved from being a hypothetical situation that merited a debate to a genuine outcry from people in the crosshairs of a war that is taking place as we speak. In order to understand how the protections provided by international human rights law and international humanitarian law could never be considered adequate, one must first understand the limitations of these laws and how they have actually been applied or respected in the past. My name is Emer Nolan, and I will discuss the fact that the one broad protection in place is not strong enough, that the limitations and the lack of enforceabilities of these laws presents another issue, and that the future without any future and I will discuss the future without any further regulation. Human Rights Watch has repeatedly called for the current international stance on autonomous weapons to be re-evaluated, specifically under the provisions of the Martens Clause, a provision that establishes a baseline level of protection in cases where specific treaties are not in place. This clause has two limbs. the principles of humanity, and the dictates of public conscience. As my teammate Katie has already demonstrated through her stories that she has shared, and Adam and Emma will be reaffirming, the actions of these killer robots violate both of these principles. Even when given a fleeting thought, it is clear that these robots do not meet even the moral standard set by the Martin's Clause. Even though this has been a contentious issue, the United Nations 6th Review Conference of the Convention on Conventional Weapons were unable to agree to even begin negotiations on new rules. This convention would not have been held in the first place had it not been widely accepted that regulation change was needed.
Point of information.
1 second. And yet negotiations stalled, showing the different positions that countries take on the issue. How can we consider protection so outdated and so out of touch with the current situation that countries cannot even begin to renegotiate their terms as adequate protection? Yes, please.
Have you got, a concrete example of showing where these killer robots, were so out of control and the LOAC was not sufficient?
The issue is not what has happened in the past. The issue is what can happen in the future. The issue is preventative measures that need to be put in place in the face of the armed conflict that we are facing at the moment and potential armed conflicts that we could face in the future. Sorry, I'm going to continue my speech. Sorry about that. The mechanisms through which countries can actually enforce these laws are inherently limited. The slow speed by which a country could be taken through the international court system is only a secondary issue when all the barriers to a case actually being taken in the first place, such as political allegiances between countries involved, are considered. The steps that can be taken in order to prevent any sort of attack of this sort are methods of enforcement, such as sanctions and public international condemnation, do not matter in the moments when it matters most. Instances where international human rights violations have been unstoppable in the past. In countries such as Poland, where violations of LGBTQ rights have taken place systematically over the past years, the international community has remained powerless. The courts have been unable to prevent the detention of Uyghur Muslims in the re-education camps in China, which have been described as appalling violations of the most basic human rights. In this instance, China simply responded with sanctions of its own towards the US, feeling no repercussions. When a country's government or leader decides to commit a human rights atrocity, they do so safe in the knowledge that they can survive any international sanctions that are placed on them. Otherwise, they would not commit them in the first place. Countries conduct a risk assessment, and in the grand scheme of things, being prosecuted under human rights law is clearly not considered high risk. How then could there be adequate protections when they have never been strong enough to protect those most vulnerable from other threats in the past? Yeah.
So are you suggesting that if there were stronger penalties, that these leaders who are clearly violent would adhere to those anyways, and that that's what would stop everything from happening?
We do not have to prove that even stricter sanctions would be 100% successful. What we do have to explain is that what is there at the moment isn't doing enough. All we have to prove to win this debate is that the broad protections require more strict elements to them, and that there needs to be more preventative measures put in place before things become uncontrollable. There is one main takeaway from this debate: who actually requires protection from autonomous weapons? And the answer is vulnerable civilians. Those who have been involved in a combat against their will and deserve mercy, yet cannot be identified, those who simply have the misfortune to cross paths with a weapon that makes an error, or civilians who live in the areas that have been devastated by the development of weapons that have no regard for the destruction that they leave in their wake. Imagine a world in which these weapon systems are the norm, the long-term consequences of allowing them to become dominant in warfare. The destruction that would ensue if wars are dominated by these merciless automations is impossible to imagine, and therefore their use requires the strictest possible protections, not the broad protections that are mentioned to you by the proposition team in this debate. The development of weapons over the last century has been exponential. Weapons are smarter, more efficient killers, and their production benefits one group of people disproportionately: those who produce them. Countries investing in autonomous weapons has driven up the price of weapons as they become more intelligent and complex to produce. Weapons companies competing with one another for big contracts require them to create weapons that are even more deadly to those who cannot afford competitive protection, further unbalancing the playing field. All one has to look at is the increase in stock price of weapons companies over the last week to see that this is an industry and that the escalation of armed conflict is in their industry. is in their interest. This amoral industry requires the strictest possible regulation, because without stricter regulation, there is no motivation for countries not to invest in production and no end to the horror that could be wreaked by these weapons and the suffering of those in their firing line.
Good evening to the House, the judges and the opposition. My name is Mohammed Awan, and before I begin, I would like to quote Stephen Hawkinson on a very famous quote about AI. He said, "It will either be the best thing that's ever happened to us, or it will be the worst thing. If we're not careful, it very well may be the last thing." Elon Musk, another AI expert, shares the same thought in this matter. So far today, we have spoken about different legal instruments in place for war and autonomous warfare. My team so far has proven how the current legal instruments are providing adequate protection. I will be referring to lethal autonomous weapon systems to AI weapons in my submission. The opposition has not only misguided the House, but us as well. They have said that a reasonable army personnel would not kill any children. But I ask you, in the last 20 years of conflict between USA and Afghanistan, how many innocent children have died? And it's 33,000. Israel has been using autonomous weapons, and they've been using, which are AI monitored. They used AI weapons to kill Iranian nuclear scientists. And then second of all, the opposition has not shown no concrete evidence to show what danger AI is present to us. It's all assumptions based on their personal knowledge and beliefs. I will be discussing the alternatives from what we currently have, what the future might hold in regards to laws and treaties regarding AI weapons. There are several alternatives that we should consider. As we are very limited by time, I may not be able to go over every possible alternative. I'll start by naming a few. The very first, do nothing. Yes, that's right. That is a choice we have, simply just to do nothing and work with the legal instruments that we currently have in place. Second, ban all AI weapons. As we are well aware, by the likes of the Red Cross, Human Rights Watch, and many countries such as Pakistan and New Zealand would all love for a primitive ban on AI weapons. Thirdly, we can create new rules and laws around AI. And then lastly, ban some weapons. When it comes to AI weapons, we have three categories for AI weapons. We have semi, full, and supervised weapons. I won't describe full AI as the debate is focused around that, but in a nutshell, full AI weapon is something that can kill or engage a target on its own initiative, where the human does not need to be in the decision making. The other two types can be described as the following, according to the CRS reports published in December 2020. Semi-autonomous or human in the loop, weapon systems that only engage individual targets or specific target groups that have been selected by human operators. Semi-autonomous weapons include so-called fire and forget. Fire and forget is a type of weapon which does not require further guidance after launch. Supervised, or the human on the loop. Autonomous weapon systems in which operators have the ability to monitor and halt a weapon's target engagement at any given time. So this can be right before the weapon is about to engage as well. So that was the main alternatives I'll be addressing today. I'll start off with the one that seems almost impossible to achieve. So for a ban, there are two sides. On one hand, we have China, Israel, South Korea, Russia, the United Kingdom, and the United States, who all want to develop and deploy AI weapons. But the likes of Human Rights Watch and the Red Cross and several organizations and countries that I've mentioned before call for a primitive ban on the development and production on autonomous weapons. So I'm very sure a ban will not be an option, and that the two sides may have to come to some sort of agreement. My colleague, Ms. Khan, will be developing this point further in her submission.
Right?
Yeah.
How do you account for the variables of war, specifically when talking about the full AI weapons that you have mentioned?
So I'll be going and explain that point in a few moments, and I'll answer your question. So banning some weapons, like I've mentioned before, there are three categories. We can ban weapons that are full autonomous weapons and that have no human interaction or decision while engaging a target. So it may be easier and more foreseeable to adapt to weapons that are semi or supervised, those weapons that comply with the current laws as the law of armed conflict and international humanitarian law. Lastly, we can create new laws around AI. The EU has proposed for AI regulations in which they have laid down static rules. They have categorized AI risk in 4 bands: unacceptable, high, limited, and minimal risk. Furthermore, the EU Commission has proposed 3 interrelated legal initiatives, which can be summarized as a European legal framework for AI to address fundamental rights and safety risks specific to AI systems, EU rules that will address the liability issues related to technologies, including AI systems. I believe this will help us in solving the issues around accountability. We have been having this discussion for almost a decade now, so this will help us in achieving to let us know who is accountable for when a machine does something wrong, or if there's ever a bug in a machine, who the onus falls upon. Lastly, they will update the General Product Safety Directive, which looks after the machinery regulations. This will help answering and clearing up concerns for AI development. I would just like to finish off by saying that it has taken us several years just to justify lethal autonomous weapon systems. So I think the next phase, we need to work more quickly and effectively. The Vice Chief of Space Operation, Mr. David Thompson, has said, we are going to have to make weapons that make their own decision. From what we've heard so far, and from my personal beliefs, I think he is very much right in this matter. We will have to use the foundations of current law and build new rules upon them to marry current and future technologies to be used in warfare. Thank you to the House, the judge, and the opposition for your generous attention. I hope you enjoy the rest of the debate.
Chairperson, adjudicators, members of the opposition. On the 26th of September 1983, the Soviet Union's early warning systems detected an incoming missile strike from the United States. Computer readouts indicated that multiple missiles had been launched, and the Soviet Union's protocol in these situations would have been to retaliate with its own nuclear attack. But despite the data, despite the instructions, and despite the howling of a siren, Stanislav Petrov chose not to raise the alarm. His decision was based on distrust with the early warning system and the relative paucity of missiles that had been launched. The system had mistaken the sun's reflection off of clouds for missiles. Mr. Petrov's decision saved the world from nuclear war, and it potentially saved the lives of over 100 million people, and it demonstrates that technology won't always get it right. My name is Adam Connolly, and I will be arguing that autonomous weapon systems do not satisfy the principles of distinction and proportionality, 2 principles required under the Geneva Conventions. And on that basis, I ask you to join me in recognizing that international humanitarian laws do not provide adequate protections for the use of these autonomous weapon systems in warfare. No thanks. Technology has allowed us to do many things that might once have been viewed as being impossible, and that is not in dispute. But when it comes to armed conflict, we must not let technology become the master. It must remain a servant. As a fundamental principle of international humanitarian law, parties to armed conflict must be able to distinguish the civilian population from combatants, military objectives from civil objectives. Without being able to see how these systems would act in the unanticipated and the unforeseen circumstances of war, how can we be sure that they satisfy the fundamental principles of international humanitarian law, as is required under Article 36 of Additional Protocol 1. Now, one would be foolish to regard the principle of distinction as being a mere sorting rule, capable of being applied by even the most inexperienced of combatants. In reality, it's more complex. Take, for example, the difficulty that arises when trying to determine what a civilian participating in hostilities means. The International Committee of the Red Cross has set out guidelines that set out requirements which assist moral agents when they're navigating the multiple layers of interpretation and judgment that come with making these decisions. they're not going to be based on fixed values. They're going to be based on moral calculations and judgments, and they will require a sophisticated understanding of the invariably complex situations. Yes.
A machine is not racist, it has no feelings, it kills what it needs to kill. A human, he can be racist, he probably has no remorse towards some humans. So,
thank you. But these AI systems, they're programmed to do one thing and one thing only. But what happens when you throw a variable into the equation? They lack a broad contextual intelligence or even a common sense on par with humans. And even the relatively sophisticated algorithms are still subject to failure if they face situations outside their design parameters. Thank you. The principle of proportionality requires parties to armed conflict to ensure that incidental damage is not excessive. Now, that rule has many qualitative and subjective elements, and it is very much time and context dependent. Autonomous weapon systems are not capable of deploying the same holistic analysis that humans are able to carry out. Autonomous weapons should not be tasked with making decisions at a strategic or an operational level of armed conflict without an input from a military commander. At the operational and strategic level of armed conflict, the proportionality assessment must account for strategic and political factors in order to determine the military advantage being sought. In carrying out those assessments, military commanders will deploy a rational judgment, informed by both legal and moral norms, in addition to personal experience on a case-by-case basis.
Point of information.
Yes.
Are you putting forward that it's better to have a human decide who lives or dies in the machine? Is it just not better to not?
Yes, because current artificial intelligence doesn't have the social, it doesn't understand the social context, the psychological context. And these are the very understandings that are required to make those decisions. The delegation of human decision-making responsibilities to autonomous weapon systems is both a moral and a legal issue. Without human judgment, how can we be sure that killing is not arbitrary? Humans must be kept in the loop. As the former commander of the British Royal Air Force in Iraq, Sir Brian Burridge noted, there is an expectation in the proportionality assessment that at the end of the delivery chain, there is a human making the last assessment by using rational judgment. We cannot take the human, the commander, the analyst, those who wrestle with ambiguity out of the equation. I urge you to recognize that autonomous weapon systems do not satisfy the fundamental principles of distinction and proportionality, and thus their use cannot be said to be protected by international humanitarian laws. We know that technology should not dictate our lives, so why should it dictate the lives of others? Thank you.
Ladies and gentlemen, it has been established thus far that the question we must pose, rather than creating an all-encompassing formalized law, which is quite frankly unrealistic and not needed in the face of the adequacy of the protections in place, or pushing for a ban on autonomous weapon systems, which also echoes unrealistic ideology, is whether the existing body of law has conclusively operated within the remit of its role in respect of the use of autonomous weapons and systems in warfare. My name is Hira, and in order to answer this question, I'm going to clearly set out that firstly, there is a robust legal process for the review of autonomous weapon systems. Secondly, whether we should consider any alternatives. And thirdly, the best approach forward. There is in fact a robust legal process for the review of weapons and autonomous weapons and systems in warfare, and these are governed by this existing international law. The misimpression of the opposition that autonomous weapon systems are legally ungoverned and are not covered by the adequate protections lends greater weight to the urgent call for some new law to address them. However, weapons of all kinds are subject to the law of armed conflict, hereinafter the LOAC. A requirement of LOAC is that states must conduct legal reviews of weapons to determine if they are lawful based on certain long-standing baseline requirements. To say that the LOAC is an inadequate protection applied to autonomous weapon system would mean that the LOAC is not a sufficiently robust body of international law, and it is inadequate in governing a weapon of any kind. Indeed, it is safe to say that the existing process of legal weapons review through the LOAC is not inadequate. One must also really question and consider whether a ban on autonomous weapon systems advances a potential solution to offering protections in respect of the use of autonomous weapons and systems in warfare. In the era of modern technological advances and in the foreseeable future, We will indefinitely be doing what we are now by placing trust in a machine making and executing decisions of its own programming. For example, are we not inspired by Tesla's paving the way to promote self-driving autonomous cars? Or are we not using robots to assist with surgeries? A world which can accept Teslas can accept and expect those technologies to be applied to weapons as a matter of course. The protections offered by international law and international human rights law are adequate. Yes.
Would you not say to preserve the integrity of the artificial intelligence that is utilized by medicine in order to, I suppose, preserve that integrity? Would you not argue that there needs to be more protections for systems in warfare that could potentially ruin their reputation?
To regulate and impose heavily regulated sanctions on AI would almost mean to ban technological advances. Are we not going to move forward in society then? Thank you. The protections offered by international law and international human rights law are adequate. Warfare is an inevitable result of states advancing in technology. And a better approach to the regulation of automated weapon system is to ensure that the responsibility for ensuring that international human rights law is complied with in order for these protections to be adequate rests first and foremost with each state that is deploying, developing, and using weapons, and at the same time to retain some flexibility for requirements to evolve as technology evolves. In other words, the law that is offered now is adequate, and the best path forward is now for states to focus on creating a set of common understandings, common standards, and proposals, and uphold their international relations themselves. It is a process which is unapologetically state-centric. In conclusion, rather than being focused on a profession that the law must be changed when indeed it cannot offer a full set of protections, as to do so would be to bind or control the actions of a state, which international law never sought to do. And for the opposition to dispute that the destruction in regard to cyber warfare are shortcomings of the law is fanatical. It is better to adopt such an approach which places the onus on states to ensure legal compliance in order to minimize the ramifications of warfare. Thank you.
PUI, if you're saying that states should agree on autonomous weapons, how they're used, how they are presented in war, is that not a form of regulations that we're proposing?
The motion that, well, what the overarching theme of the proposition's arguments is that the regulations must be sought by states themselves. It is up to the states to impose international or maintain their international relations. It is not for the international law to seek to bind or control the action of the state. Thank you.
Chairperson, adjudicators, members of the opposition, ladies and gentlemen. My name is Emma May, and in closing the submissions of my team, I will be arguing that the utilization of autonomous weapon systems is not provided for under international human rights law. In fact, their deployment gravely infringes two of the most fundamental human rights, the universal right to life and the right to human dignity. Human rights law applies to the use of force at all times. They are complementary to, and they must be interpreted with reference to the specialized rules of international humanitarian law during armed conflict against other human beings. Therefore, in this debate, we must consider the negative implications of the use of force through such weapons from a human rights perspective. Firstly, according to Article 6.1 of the International Covenant on Civil and Political Rights, every human being has the inherent right to life. No one shall be arbitrarily deprived of his life. The key term on this point is the word arbitrary, because in the context of warfare, it is argued that the determination of life or death by a machine in itself is inherently arbitrary. Point of information.
Yeah.
In warfare, traditionally, when a bomb is dropped, there are people who are arbitrarily killed, so that does somewhat go against what you're saying there.
Sorry.
In traditional warfare, when a bomb is dropped, there are people who are arbitrarily killed, and that is in traditional warfare, and not specific to just AI warfare.
Yeah, I'll be going on to this and my point against human dignity.
In the context of, it is an implied assumption of international human rights law that the final decision to use lethal force in warfare must be reasonable and it must be taken by a human being. Machines. Yes.
Is the point of this not debate whether or not the protection offered is adequate or inadequate, rather than whether the use of autonomous weapons are correct or incorrect?
Thank you. Well, my argument is, well, how could they be considered adequate if they fundamentally breach two?
So adequate protection, apologies.
Adequate protections, yes. How could they adequately protect human rights if they breach human rights? Machines cannot reason in the same way humans do, and therefore they cannot take reasonable decisions alone. Article 1 of the Universal Declaration of Human Rights provides that all human beings are endowed with reason and conscience, and they should act towards one another in a spirit of brotherhood. And it is clear to all of us that that is not something that a machine can do. Although the language is outdated, it is clear that human rights law strongly emphasizes human reasoning and human interaction in order to adequately protect the right to life. Secondly, Article 1 of the Universal Declaration on Human Rights holds that all human beings are born free and equal in dignity. It is submitted that autonomous weapons significantly impact the right to dignity of those targeted in warfare. The decision by a machine to use force in general against a human is the ultimate indignity to human life. The right to human dignity is based on the idea of equal concern and equal respect for each individual. Death or injury by a mechanical algorithm means that people are treated as replaceable entities, as mere objects, as an inconvenience, rather than as human beings with inherent dignity. A decision as radical as the one to deploy force should only be taken upon contemplation by a human being who can assume responsibility for the outcome. As mentioned by the late Christoph Haynes of the UN, a bloodless machine without morality or mortality cannot comprehend the gravity of killing or injuring another human being. And without this sense of understanding and accountability on behalf of the autonomous weapon, human life will ultimately be devalued. So next, I must draw your attention to the claims by psychologists that the proper operation of the human brain hinges on hope. As noted by Mr. Haynes, as humans, we believe that the harshness of reality is often bearable because we believe that the worst will not happen. In the context of war, knowing with all the accuracy that modern science can offer that you will be confronted by a robot who will most certainly end your life leaves little to no room for the possibility of an exception, for a moment of human compassion or a last-minute change of mind. Dignity depends on hope. Algorithms should not make the use of force against people inevitable, and therefore it is indisputable that machine autonomy in warfare can deeply damage our right to human dignity. So as I have demonstrated, there is a fundamental incompatibility between the values of the human rights regime and the use of autonomous weapons in warfare. Yeah.
Sorry, what's the difference between someone remotely launching a rocket or an algorithm that's running, that's been created by a programmer, which is a human? So what is the difference? Because you're saying remotely in one location, you don't know who you're going to kill, you're going to bombard a location. So what is the difference between an algorithm and someone remotely killing someone?
The difference between that is the decision that the autonomous weapon can make between life and death, and that in itself is inherently arbitrary, breaches the right to life and the right to human dignity. Now more than ever, we must realise that there will be dire consequences if we fail to recognise the truth that my team have demonstrated here today. I implore you, ladies and gentlemen, to contemplate the question posed by my colleague earlier. How can international human rights and humanitarian law even be considered as providing adequate protections when the deployment of autonomous weapons ultimately violates the fundamental principles and fundamental rights of those very same regimes? I will end on a comment by the UN Special Rapporteur on arbitrary executions. Technology will keep on developing and will keep on pushing up against the boundaries of human control. Those wishing to retain human control over life and death decisions will have to be equally relentless in their protection of this value, which once lost can never be regained. Thank you.
basic metric by which this debate must be judged is, could we be doing more to protect civilians in relation to the dangers posed by autonomous weapons? And as the first speaker from the proposition said, could we be doing more to minimize their impact and the impact on the civilians involved in these conflicts? As was mentioned by the proposition, there is robust protection in place in relation to certain weapons, but this protection, while it is robust, is not specific. It is not specific to the dangers posed by autonomous weapons and the unique challenges that they pose. The LAOC does provide, as was mentioned by the proposition, specific provisions for chemical weapons. In that case, why not autonomous weapons also? Those provisions were written at the time when it was important to have specific provisions for chemical weapons during their use in conflicts at the time. At the moment, the weapon of our generation is an autonomous weapon. This is the weapon that our generation and that the international human rights courts need to provide specific regulation for. It needs to be the exception, not the norm. Reasons for this is simply because automated weapons operate in a different manner to those which are manned by a human. Specific examples of ways in which you could specifically regulate for this include things like ensuring that there is a minimum level of human involvement in a decision-making process of a killer robot or of an automated weapon. Currently, this is not legislated for. This is not provided for. There is no way to ensure that there is a human overseeing any level of the actions taken by a robot. There is no reason why no provision could be included to say that there has to be a minimum requirement for this, and that a minimum requirement needs to be placed into any new form of weaponry that is being built. These laws need to not just apply to countries, but they need to apply to the businesses that are building these weapons and that are creating them for countries to use in their conflicts. It is important to put these measures in place at the start to ensure that there is a limitation on the power that these robots have, we currently have no way of knowing, are these weapons able to kill one person at a time? Are we talking about a sniper robot? Are we talking about a robot that has the power to blow up an entire hospital in one go? Do we want that to go completely unsupervised? Do we want that to happen without any level of human control and no control over the possible errors that could be made? At the moment, that is not legislated for at all. There is no specific provision. And without that, there is no way to ensure that there is adequate protection for the people that are involved in for the citizens that are involved in an armed conflict. Even Elon Musk has signed the petition against the use of killer robots. And if somebody of that type, who is obviously so pro-automation, believes that there is a problem here, then obviously there is. When you have a person, when the proposition talks to you about a Tesla and say that it is a self-driving car, there's a person in the Tesla. There is somebody who has some level of oversight over what is happening and is not simply one robot making a decision with no level of human oversight over it. We think that the problem is that a machine has no respect for human life. We think that when a machine makes a decision, it has no mercy, it has no remorse, and it has no regard for the collateral damage. A machine has no way to relate to the people that it sees in front of it. It has no way to decide that maybe the child that it sees in front of it has a parent, or maybe that the person that they see in front of it has children. A machine has no mercy, and we think that that is really important in the face of an armed conflict. The problem is that a machine does not think twice. We think that providing specific regulations, that there is no harm in doing so. We do not see the problem, and that we think that it is inadequate to not legislate specifically for these automated robots, because the damage that they can cause is so different to that of a traditional weapons system. Thank you.
Panel, it is my pleasure to close the debate. I firstly believe that it's only appropriate to recognise that there have been important arguments put by both sides of the House, and that this issue is clearly a complex one which does not have a straightforward solution. Both sides of the debate do agree on one thing, that there are flaws and failings with regards AI. The point of clash exists with how we think about how it should be dealt with. I opened the debate with the overarching principle that while there are flaws in offering full protection, these are not failings of international law or humanitarian law in particular. It is a failing of other influences of warfare. Anne spoke about the law in place and the fact that it is broad and adaptable. Mohammed spoke about the alternative in place for how we can potentially offer more protection. And what this shows is that international humanitarian law is adequate in the function that they are made to serve. And that the issues lie externally to that. Hira finished by putting forward how these alternatives can work. We can agree with the opposition on aspects of the alternatives. However, we do not agree that they are needed on a basis of a legal failing, but other failings. The first speaker brought forward the point that there are no regulations in AI in warfare. However, Anne rebutted that there is the LOAC and that regulates the conduct of warfare. The AI could fall under that. The law constantly evolves, so therefore a broad definition is required. The op referred to the fact that a broad definition is a negative thing. However, it isn't, because that's the only way that you can evolve and apply it to the times that we are living in. There is also the seeking for heavy regulation. However, the question is, how will you implement this and how will you make sure that leaders are following along with the regulation that has been asked for? And then going on to the second speaker, they discussed that what could happen in the future. However, we've already established that the law is broad and can apply to future contexts. Therefore, it is questionable whether that is the future that we are facing. Stronger sanctions were suggested as something that is required. However, the proposition asked whether it is likely that this is the solution that it's made out to be. Leaders who engage in warfare are unlikely to be stopped due to sanctions. And therefore, international humanitarian law do serve the purpose that they put out to serve, which is to reduce the harm of citizens. It is a very citizen-focused approach. The third speaker spoke about the inaccuracy of AI, which I can agree with. However, this does not fall within the realm of the functions of international and humanitarian law. Its regulation lies elsewhere. The speaker put forward that a human is more suited to decide who lives or dies. However, it is questionable how this alone interacts with international and humanitarian law. This side of the House is not promoting the use of AI. However, it should be recognised in this debate, we are not discussing what is the best way to decide who lives or dies, but the best way that we can minimise the damage that is put onto people's lives by the inevitable and unsurprising warfare. The final speaker put forward that AI in modern warfare leads to arbitrary deaths. However, this side of the House would put forward that unfortunately arbitrary deaths are a result of any war. So that does lack persuasion when we are considering the effect of international and humanitarian law with regards to protection. To finish this debate, the flaws in warfare have and will continue to cost the lives of many. Neither sides of this debate want that to happen, and both sides are putting forward what they believe to be the best solution for that. I urge the panel to recognise that the functions of humanitarian and international law and consider it accurate in the protection that it has the capacity to provide. I urge you to propose.
Firstly, I'd just like to invite everyone to give a round of applause to all the participants. Very convincing. What I propose that we do next is that the judges will deliberate for roughly 15 minutes. You're invited to take a break in that period of time. I will note that there is a bar downstairs, so people can make of that information what they will. So thank you very much for attending, and this season.
Thank you. It's fallen to me to give the result of the debate tonight. Before I do so, there's a few comments I'm just going to make. Firstly, as the participants, as you know, this is a debate sponsored by the Bar Council of Ireland, and I think the format of the debate is interesting because if you pursue a career in the law, particularly if you pursue careers as barristers, one of the things you will find is that you are frequently thrown together in teams of people working on cases that change. The short term, you come together, you work together to do a case with solicitors, with junior counsel, with senior counsel, with clients, and then you move on and you're doing something else with a different group of people. And there's a real skill in being able to come together with people who are not your natural teammates. You're not from your university. They're not necessarily people you know well. You may only know them in the context of being opponents in other debating competitions. and you have to make a team out of all of those differences, and that's a real skill, and obviously it's a very significant element in the judging of the debate tonight. Secondly, I was also asked to judge this debate last year. Last year it was held over Zoom, and it's a completely different experience and a much more positive experience to be listening to the debaters debate in person. It's also a completely different experience to have the benefit of an audience, admittedly a small audience because of the rules and the sort of residual constraints we're operating under, but an audience, just to know that there's an audience listening enthusiastically and responsively to what you're saying really adds to the way the speakers deliver their speeches and to the enjoyment of those of us on the panel who were judging it. So thank you very much to the audience as well. The motion that the Bar Council gave you to debate tonight was undoubtedly an extremely difficult one. It was one which, as I read it, when I got the papers before I came here tonight, I had some difficulty in working out some of the concepts that were involved. And I wasn't sure I fully understood what the debate was going to be about before it started. So it was an extremely difficult debate. It was also, in many respects, extremely timely, because I'm sure when the motion was set, we didn't think that we were going to be watching a rolling newscast of an invasion into a sovereign country. And I think that probably added to the difficulty for the opposition, who I think in fairness did have the more difficult side of the motion. It's hard to make the case that anything to do with war is adequate when you see the effects of war being played out on our screens every night. That said, the standard of the debate was very high. It was clear that all of the speakers had researched the topic, had thought about the speeches they were going to give, had tried to identify and divide out amongst the team members the relevant issues to talk about. And certainly the academic standard of the debate was very high. A slight weakness was the number of you who read your scripts. Some of those scripts were very well put together. They were eloquent, but it was very obvious that you were reading. And funnily enough, I noticed it more, perhaps because we were live this year than last. Those who read from computer screens were more obviously reading than those who read from notes. It was quite distracting at times because people were constantly engaged with their screen, and those who tended to speak from notes were a bit more fluid in their overall presentation. I think we also saw that speakers who engaged with and responded to points of information where they had to think on their feet and deliver a reply tended to do that well. Once you moved away from the script and engaged with the issues, actually people got much more fluid. And we also saw that very much in the last two speakers who delivered the formal replies, even though they were quite difficult. One of them was very emotionally engaged and passionate about the topic. The other one was very well structured, and even though clearly had only just heard the speeches that were delivered by the other team, was able to go through them sort of with a forensic skill and respond to each of the points that have been made, or each of the main points that have been made by the speakers on the other side. That said, the task is to tell you who won, and by a unanimous decision, the judges have decided that the team that won were the opposition tonight. And part of that was that they have the benefit of the standout speaker, who all four judges agreed was the standout speaker, who was Katherine Ahern from the University of Limerick. So congratulations. I believe there are awards for all of you, which the chairperson of the Bar Council will now distribute, both to the winning team and to the runners-up.
Start here, Katherine. Thank you so much.
You're welcome.
Sorry, there you go. In order. Thank you, Emma.
And the opposition, as I said, everybody, the standard was very high, everybody spoke well, and the opposition were lucky to have both the more difficult side of the motion and the proposition had a more difficult style of the motion, and also facing the opposition who were very good.
Thank you everyone for partaking, and it's not just the Bar of Ireland upstairs. I'd like to mention that there is a Bar of Ireland downstairs. So hopefully we'll see you all down there. Congratulations to everyone, and thank you so much for partaking, and also thank you to all our judges. So well done.